Joining me now is NBC News Justice correspondent Pete Williams. And Pete, why did this case come before the court? My understanding is each of these cases came up in different circuits, and there's a split at the lower federal court level about whether or not these parties have a claim.
That's right. The Hobby Lobby won its case in the 10th Circuit Court of Appeals in Denver. The court said that the Constitution does give personal rights to corporations. The Supreme Court has given a number of them over the years, including, you most recently noted, free speech rights. And for that reason and many others, it said this is a valid right for Hobby Lobby. The Third Circuit Court of Appeals, though, in the Conestoga Wood case, the other one the Supreme Court agreed to take today, said no, not only can corporations not assert this claim, but the owners of the corporation can't claim that it violates their rights because it's the corporation that provides the contraceptive care, not the individuals. A couple of things to note here before we go on. Number one, the Hobby Lobby doesn't object to all the provisions of the Obamacare contraceptive mandate. Right. Only 4. They say those 4 are tantamount to abortion and they violate their religious beliefs. And secondly, many of the religious groups that are involved in these cases in the lower courts, and there are like 40 of them, that have been filed on this question of whether for-profit corporations have religious rights, actually support many of the goals of the Obamacare law. Many of them support, for example, universal health coverage and have said so in their legal briefs. So it is an interesting constitutional question, one the Supreme Court has never answered before, and one of the reasons they took the case is precisely the one you mentioned, because the lower courts are divided. And in the lower court case with the Mennonite furniture manufacturer Conestoga, that court, the party there made an explicit argument based on Citizens United that was rejected by that lower court. I mean, they basically said, look, the Supreme Court handed down Citizens United. It confers these First Amendment rights. I don't see how you could draw the line between those First Amendment rights and these as well. Right, and the 10th Circuit said just the opposite, right, that it's a continuing line. So the Supreme Court's going to have to sort this out. You know, there are a lot of legal scholars here on this question who don't think that it all hinges on Citizens United. The judge who wrote the 10th Circuit decision thought that it did. That's one thing the court is going to have to sort out. But this is not the Citizens United is not the only time the courts have ever said that corporations can exercise what are, in essence, individual rights. Some they have, some they don't. NBC News Justice correspondent Pete Williams, thank you so much. You bet. Joining me now, Sandra Fluke, former Georgetown law student, now a social justice attorney. Last year, Republicans famously denied her a chance to testify at their House hearing on insurance coverage for birth control. And Tim Carney, senior political columnist of the Washington Examiner, visiting fellow at AEI, a conservative think tank. And Tim, I'll begin with you. You have been a vociferous defender of the conscience clause of whether it's religious institutions, Catholic hospitals, and educational institutions. Do you think that extends to just any for-profit run corporation?
Look, Barack Obama has his own sexual morality. I have my own that follows the Catholic teaching. They differ. That's great. This is a free country. Guess what? I don't think Barack Obama should get to impose his morality on me the second that I go into business.
But you think an employer should be? I mean, this to me is the key element here when we talk about freedom interests. Is that the employer here is saying that their freedom is being impinged because the Affordable Care Act requires them to pay for insurance that gives birth control without a copay, right? The question is, not giving that, right, has some encroachment on the freedom or liberty of the employee.
I don't see that as having any encroachment on the employee, because the employee is perfectly free to go out and buy his or her own birth control separately. You guys at MSNBC, you infringe on the ability of your hosts to go out and make, anti-gay comments in their personal life. I think that's great that you have that right, and I think it's great that you make those decisions. To say that I am not going to pay for my employee's birth control is not the same as saying my employee may not get birth control. That's a distinction I think is very important to make, and I think is upheld in previous, court jurisdiction, court case law.
Sandra.
Yes.
So what do you think about that argument?
Well, I think the problem is that the argument goes much farther beyond the contraception issue, which, as you pointed out, this could be about a lot of different aspects of health care. An employer could decide that they want to deny access for blood transfusions. And I suppose Tim could say you can go out and pay for your own blood transfusion because your employer doesn't believe in that on a religious basis. But many of these are cost-prohibitive health services. And beyond that, it goes even beyond health care. It's a corporation picking and choosing which types of laws they want to comply with. And our belief in this society has always been that we protect the religious liberty of individuals in their private lives, but that when you cross that line and go into the public sphere and decide you want to operate as a company, make a profit off of the public, you need to abide by the public's laws.
But that's not really true, Chris. Look at this. Right now, you and I are both, putting our opinions out on television. You are making money off of this. I am not. Would it be okay if the federal government said, oh, well, Chris is in business on TV, so we're going to infringe on his First Amendment rights, but Tim and Sandra, well, they're just doing this not in business.
No. But that's a bad thought experiment for about 90 different reasons. The first being that the press is a named party in the First Amendment, and there's specific
and
constitutional.
Religion is a named party.
Yes, there is, but there's specific constitutional case law around that. But taking that aside, the argument that Sandra's making, and I think this is the key point here, is there is no iteration of the argument that doesn't prove too much, which is to say this: there are presumably some faith traditions that believe that AIDS is the punishment of a wrathful God, and that it would violate the conscience of the employer to pay for AIDS coverage. And I cannot imagine in any conceivable universe in which a just society could allow a corporation, let's say Goldman Sachs, let's say Microsoft, let's say whoever, to assert that conscience clause to deny paying for AIDS treatment.
What's also really important here is that it doesn't
That is not an absurd example.
It doesn't have to be a belief that is recognized by organized religion. It can be as absurd as we want, because the court is not going to decide whose religious beliefs are legitimate and whose aren't.
Tim.
The Religious Freedom Restoration Act has been in place for 20 years. A Democratic Congress passed it into law. It was signed in 1992. We haven't had any of these outrageous examples. Right now, we have an example where a Catholic teaching that has been around for millennia, that sex, family, marriage, love belong together. That is the idea behind the Catholic opposition to contraception. Or in the Hobby Lobby case, the Christian idea that the morning after pill, which can end a human life before implantation or even at implantation, that these are wrong. That this is not an absurd example.
The specific circumstances of that theology, that does not matter. You cannot adhere, right, to private theological justifications of essentially what is either a public policy or constitutional matter. That's precisely the issue, right?
So if the government thinks that it's a compelling interest to get more people contraception, I don't agree with that. But if the government finds that way,
well, to get women health care,
there are less intrusive ways to get women contraception. This is obviously not the least intrusive possible way, and this is what the case law points to. This is an idea to force employers to pay for it.
One of the things that's really important that they are going to come to in this case is what would be a less intrusive way of offering contraception comprehensively to women. And it's really interesting that some have actually argued that the government should just provide the contraception. Well, we hear this type of argument from Tim, but at the same time, we're seeing conservative lawmakers cutting back on funding for programs like Title X that do make sure that there's affordable access. So there's an attack on allowing employers to be required to provide this insurance coverage on insurance that employees pay for, at the same time that there's an attack on public availability through clinics.
I think
so this is absolutely an attack on women's health care.
There's a very important, really central concept here, and it goes back to the Civil Rights Act and the public accommodation title in the Civil Rights Act, right? I mean, there were people in the Civil Rights Act who are saying essentially, look, you cannot tell me, government, who I have to serve at my diner or at my motel. Like, you don't get to tell me that because I have my beliefs and this is a privately run business. And there's a recognition both in the statute of that law and the constitutional case law that affirmed it, that when you enter into the marketplace in these transactions, you are not allowed to bring forth all of your beliefs, right? There's a certain kind of way we meet each other in the marketplace. It's going to be very interesting to see how that plays out in this case. Social justice attorney Sandra Fluke, Tim Carney from the Washington Examiner. Thank you both.
Thank you.
Coming up last night, we discussed how the historic diplomatic breakthrough between the United States and Iran may have just dealt a death blow to the neoconservative agenda, which has banged the drum for war with that country for years. Tonight, we're going to talk about this with the former U.S. Deputy Secretary of Defense, Paul Wolfowitz. Yes, him. Don't go away.